Good evening, everyone, and welcome to today's webinar on estate planning. We're so glad you could join us today for this informative and engaging session on estate planning. Now, whether you're here to learn about securing your future, managing your assets, or you're simply curious about the process, we've got you covered. But before we dive in, allow me to introduce M&M Law Group. We are a full-service law firm specializing in estate planning, real estate, corporate law, family law, employment law, and dispute resolution, amongst other practice areas. And we are dedicated to providing tailored legal solutions to meet your needs. Now on to the exciting part, our presenters. Leading today's session, we have Mr. Kioko, one of the partners of the firm, with extensive expertise in matters trusts, wills, and making sure that your estate plan is foolproof. Joining him will be Mr. Bwire, also a partner at the firm, with extensive experience in estate planning and wealth management. And together, they'll take us through the essentials of estate planning, from protecting your assets, safeguarding your future, and ensuring that your loved ones are well taken care of. So once Mr. Kioko and Mr. Bwire are done presenting, we will have a Q&A at the end of the session. But you don't have to wait until the very end to ask your questions. So if something comes up while Mr. Kioko and Mr. Bwire are presenting, simply type your question into the Q&A segment. At the bottom left of your screen, there's a little triangle, square, and circle icon. Click on it, and it will direct you to the Q&A segment. We want this session to be interactive, so do not hesitate to ask questions and engage with us. And we will do our best to answer as many questions as possible during the Q&A session. With that, I'll hand it over to Mr. Kioko and Mr. Bwire to get us started. Mr. Kioko, the floor is yours.
Oh, thank you, Esther, and good evening, ladies and gentlemen. Once again, thank you so much for finding time to engage with us this evening. Mr. Bwire, may you show your face so that we can start? Say hi to the viewers and listeners.
Hello, everyone, and thank you. Welcome. I'm looking forward for an educative session with you.
Thank you. Welcome. We, like Esther said, we are hosting you today to discuss issues concerning estate planning. And many times when you use the word estate planning, people wonder what is it we are talking about. It's about how you can manage your property for your own prosperity and for your dependents or the people who rely on you. In this discussion, we want to be interactive, and because we all come from a family, we all have things we would want to hear, we all have our fears, we all have our theories, we would want it to be very interactive. I must pinpoint that it's a topic that is very dear to me, because in my 20 plus years in the practice, it's one of the dynamic areas of practice that keeps questions keep on cropping up. Confusion. I had this. This is how it was done in another situation. And then despite the law being there and guiding us, we still have very many other issues that arise. So we will be discussing 3 broad categories on estate planning. And the first one would be, how can you, while you're alive, enjoy your property and pass it on absolutely to your heirs? That is one of the categories we will be discussing. The second category will be, how can you also plan to pass on your property to your dependents or heirs while you are still alive, but that passing on will take effect once you pass on. That's the second category. The third category will be, what happens then when you decide to enjoy your property and leave it without any directions, and then you put it like liwe liwalo. I will be taking you through the first segment on how to pass on property while you are alive absolutely to your heirs and independence. And this is arguably one of the most effective ways of managing your estate when you are alive for your own benefit and for the people whom you leave the property to. The most obvious way is when you decide in your lifetime that I'm going to leave this thing to A or B, and you give that as a gift. We call it gift in life or gift in the Bibles in law. So you decide that I'm going to give this land in Mombasa to my daughter A, and you transfer it. That way you will have resolved any issue concerning your succession. Indeed, when we are discussing nowadays, we are talking of estate planning. It is a new concept that is incorporating the traditional succession and also controlling your things while you can dictate what will be happening. So in the Bible's gift, when you pass on to somebody when you are alive, you transfer the car, you transfer the land, that's absolute, and nobody can question that. There are instances where you hear families have questioned that, but in law, you can morally maybe think about questioning it, but in law, you cannot question when somebody exercises his decision to pass on that property to another living person while they are all alive. That is an effective way of planning and passing on. The second way known in law is the creation of a trust. Trusts have received a very recent argumentation in terms of how they have been operating in this country. But now the law has been refined even further. And what happens in a trust setup is you as the property owner, and we call you in law asset law, you decide everything I own, or at least part of what I own, I want it to benefit my children, my wife, a friend, or whoever you want to benefit. And then in your lifetime, you create what we call a trust. A trust is managed by trustees whom you appoint, and they will take care of that property for the beneficiaries you will have named in your trust, and for generations to come. It's a very interesting way of managing your property because it can transcend up to this very many generations, up to the 7th generation of your as people devolve from you. So a topic on trust will be discussed later, but for now, it's a question of creating it and transferring your property, the ones you want to pass on to your people, to that trust. The trust is a legal person. It will manage, the trustees will manage the property and distribute according to your wishes and according to the dictates you will have put in the trust to the people you intend to benefit from that property. So those are two of the main legal ways. I'm using the word legal here with emphasis. Legal ways of transmitting your property while you are alive and will be effective even when you are gone. One of the main advantages of having a trust is because even you as the settlor or the property owner, you can be a beneficiary. You can also be a trustee. So you'll be in control. And even if you step aside, I mean, if you pass on, it will still go on and to continue managing your property, and your wishes will be as enshrined in that trust, will go on and on. I am alive, having been in this country and elsewhere for the last 5 decades. I'm alive to the fact that it's sometimes people don't know how long they are going to be around this world. And so there are those fears of, I may need to retain 1 or 2 things for my own sake. What if along the way, I have passed on this property and I'm not going to, I'm still around? Those questions come. At times, even people come for estate planning or for making of wills, and they are not so sure that they want to determine everything. They still want to retain a portion for themselves and all that. With a trust, or with a clear mind on passing your property through a trust, you do not need to worry about yourself, because you can also name yourself as a beneficiary in that trust. If you do not do these the two things of passing on when you are alive and effectively, then the law somehow also takes care of the other situations. And these situations, as we'll be discussing as the evening moves down, the law also recognizes situations where you may not have done the two issues I've discussed above. And I want to invite Mr. Bwire to now discuss the issue on how can you also pass on the property, but retain it until the time you pass on. What I'm saying is, there's times you can decide, when I die, this is what I want to happen, but that will not happen until you pass on. So Mr. Bwire, kindly take the audience through that process. Mr. Bwire, you can hear me?
Yes, I can hear you, Mr. Kioko. Thank you. Thank you very much. As indicated by Mr. Kioko, I'll be taking you through the various ways in which one may decide to pass their property while they are alive, but such wishes of the passing of the property will only kick in when that person has demised or has died in this case. There are four ways on which one may do or may decide to undertake such passing on of the property. One of the ways is nomination. The first way is through nomination, which I'll be discussing. And the second way is through survivorship. And the third way, they are what we call gifts in contemplation of death. And the last one I'll be discussing tested succession. Tested here means where it involves the preparation or drafting of the will, so that in case your time will come, then your wishes as provided in your will kick in or step in. To begin with, on a nomination. Here in nomination, we look at instances, for example, like cooperative societies, like pension schemes, where the nominator, here the person who is investing in such a cooperative society or a pension scheme will always be required or requested to nominate someone, the person who will step in to benefit in case the nominator will pass on. In this case, the nominator, usually as provided by the law, will always have control on ownership of the property that he nominates the nominee. So the issue here is the nominee will only take over upon the demise of the nominator. On the second now aspect, that being the survivorship. Survivorship here, we are discussing about properties that are jointly owned. Jointly owned in a way that the shares or the interest of the joint owners are not distinct. You cannot ascertain, they are not definite. So in this case, the surviving, when one of the owners, one of the joint owners passes on, the surviving, those who remain, will take over the share of the joint owner who has passed on. An example of that could be perhaps joint bank accounts. And there are also issues on joint tenancy. On tenancy, we have joint tenancy, we have tenancy in common, where tenancy in common, unlike the joint tenancy here that we are discussing, tenancy in common, the share in respect of the owners in common are distinct. They can be ascertained. So that in a common tenancy, survivorship may not or will not arise, as opposed now to the joint tenancy, where survivorship will kick in. The other aspect is the gift in contemplation of death. Here in Latin or in a legalese, they are usually called donatio mortis causa. What are gifts in contemplation of death? These are gifts that are done by one who at or in common circumstances, they are contemplating death. Maybe they are suffering, they have maybe severe illness. So they are actually contemplating that maybe soon they may live or they may die. So in such a case, one may opt to give gifts in contemplation of their death. The only condition in such a passing on of a property is that such a gift must be made in contemplation of the death, and the donor must also be capable of revoking it, of revoking the gift in case they survive the donee. So the donee must survive the donor. And also the gift that is being passed on must be declared and actually delivered to the donee. Of importance to note in such a passing off is that where the donor survives the donee, they can always reclaim back the gift. The donor always has control over the gift. And also to note is that in a scenario where a gift had been offered or given to the donee by the donor in contemplation of their death, and the donor maybe in one way or the other decides to commit suicide, such a gift by law will not pass to the donee. The other way I'll also discuss is the issue of tested succession in this case. Tested succession involves preparation of a will. And in this case, one may or might ask themselves, what is a will? A will in this case is a testamentary disposition by one person who draws down a document, a legal document, whether by himself or by the assistance of a legal expert, a legal document that indicates or demonstrates their wish upon their properties, how they would want their properties to be dealt with, how they would want their properties to be distributed upon their death. So there are two categories of wills. One is a written will, and there is also an oral will. I'll start with the written will. A written will has various legal requirements or formalities that must be followed. And one of them is that a written will must be done by an adult of sound mind. That person must be an adult, and that person must be of sound mind. Secondly, that will, the testator, in this case, the testator is the person who is attesting to the will. The testator must be doing the attestation voluntarily. Free will. That is the key thing. So that voluntarily, in essence, means that that testator must not be influenced by either duress undue influence, either mistake or fraud. And thirdly, the testator must approve the content of the will. He or she must give approval. They must approve the content of the will. And on the other issue is also the will must be attested. It must be witnessed by at least 2 competent, independent witnesses. One may ask themselves, who is a competent witness? A competent witness is a witness who is an adult, a witness who is of sound mind, and who is an independent witness. An independent witness for purposes of succession is a witness who is not named in that will as a beneficiary. So it is important to consider that when you are electing the witnesses to attest to your will, they must be competent and independent. So that by independent, try not to involve the beneficiary in that will to be a witness. I think those are the requirements for the will. And the other aspect also is on now the oral will. As I had earlier said, there are 2 forms. The will takes 2 forms. That is the written will and the oral. The oral will also takes the same legal formalities as the written will, only that the oral will is not put down in writing. And secondly, the oral will only take effect if the testator or the person making the oral will passes on within 3 months from the date of the making of the will. But remember that even in oral will, the issue of the witnesses still arises. The threshold of the witnesses as applied in the written will still apply in the oral will. Upon making of a will, it is important to note that even though a will is reduced in writing and the testator has given his expression or directions, it is important to know that a will is a document that is subject to be vetoed. A will can be impeached. A will can be challenged. How? One of the ways a will can be challenged is, 1, if that will did not follow the laid down legal requirements as I had discussed. Secondly, is if the will did not stipulate or did not provide for reasonable provision to a dependent or a beneficiary of the testator. Let me give an example. If one decides to do a will, to prepare a will, and for one reason or the other, they decide not to allocate or apportion any of their properties to one of their children or the spouse. If such an omission is not explained in that will, in this case, I mean, if you decide to leave out your child, who is a direct beneficiary to your property, you must indicate the reason why you are doing that. Maybe, for example, you may indicate in your will that I will not be bequeathing or I will not be leaving property A to maybe child 1 or child B or child C, for the reason maybe, for example, they were physically abusive to me or to the maker in this case. You actually need to state the reason why you are leaving that direct beneficiary out of the will. Failure to do that, that beneficiary will or will likely approach the court and challenge that will, where an omission or in this case you decide to leave them out and you don't give any reason. In as much as a will is a document that you express your wishes, but it must also, the courts over time have insisted that there are parameters that must be followed. There are various or several advantages of making a will. And one of the advantages of making a will is one, the testator will have the freedom. They will decide how their properties will dispose upon their demise, that is. And secondly, preparation of a will in a ordinary setting will avoid family disputes. More so in our African setting, we know what happens when one passes on and leaves their property behind without a will. Of course, there will be always wrangles. So wills come in to cure such issues. And also, when you prepare a will, one has the advantage of maybe deciding how they would want their sending off to be done. Their wishes can be given in that will. And also the other advantage is that the testator or the maker of the will has control. You have control on how your property will be distributed. You may decide who will take property A or property B and in what portion or ration. And further, the will gives the testator an advantage to decide or to appoint the executors who will carry the wishes of the testator. In of the four ways I've discussed, that is the nomination, the survivorship, and the survivorship gifts in contemplation of death, and the tested succession. It is important to note that if there is a property that has been catered for, that has been dealt in any one of the four ways I've discussed, then that property will not save for the one in the will that will undergo probate. The other three, such properties will not be subjected to the normal succession process. You don't need to undergo the normal succession process so as to gain access or ownership of a property that was given to you by nomination, a property that was given to you by survivorship, or a property that was given to you through the maker contemplating death. So I think I've discussed the various ways in which one may have control to pass off their property while they are alive, but the passing off will only kick in when they are gone or when they are dead. The other arm now we'll be discussing is now the intestate. Here, the intestate means where one has gone, has passed on, the property left behind has not been catered for in either trust, inter vivos gifts, it has not been catered for under nomination, it has not been catered for under survivorship, it has not been catered for under gifts in contemplation of death, and it has not also been catered for under tested. Maybe there was no will. So we are now discussing what happens to these other properties. Now I'll be inviting my colleague, Bona Kioko, to take over and now discuss now the intestate succession.
Well, thank you, Mr. Bwire, for that precise and very pointed presentation. Viewers and listeners, very interesting way we have structured this presentation in a manner that we've given you how you can control it when you are alive, Absolutely. Now, Mr. Bwire has taken you through how can you control it when you are alive, but you're not passing it. It will only pass upon death. One of the most interesting aspects of what Mr. Bwire has discussed on survivorship, just as a small story, is that when we talk of survivorship, sometimes the people who own things jointly can pass on at the same time. And interestingly, the law has taken care of that. They say if you pass on and you are on jointly at the same time, the youngest of you will be presumed to have survived the older one. That's what the law presumes. The law further goes and says for spouses, because you might not be talking about age, the law presumes spouses, if they pass on together and they have joint property, they are presumed to have passed on simultaneously. Why the lawyers of those times before we come about decided to decide so, it's because there has to be in law we need to have divinity. We have to be a defined way of dealing with things. Now, Mr. Bwire has invited me to discuss now what I called in the beginning of my presentation, the liwe liwalo. Mali ni yangu. I've used it the way I want, and I don't care. When I go, I go. You are left there. Deal with the property the way you want. And that is now what we call intestate succession. You have declined or failed, or maybe you delayed. We all want to live along. You delayed in planning how to devolve your property to your beneficiaries or heirs. Maybe at times you thought maybe you'll use all of it, and you don't. So the law comes in to fill that void, and that is what we call intestate succession. I must pinpoint that this is one of the areas where most of the epic battles you've had or witnessed in the courts come in. Why? Because your freedom to have willed out this property or to have decided what to be done is taken away, and the law sits on the throne, and the law now comes to decide what happens. In intestate succession, one of the most annoying bit about it is because you leave the people who are dependent on you at crossroads. There is nowhere to begin, and they can actually, the law deems them to be intermeddling if they use your property. So the moment somebody passes on and the intestate succession kicks in, it is like the law has taken over from you, and the beneficiaries can only benefit from that property if they undergo the court process. Key beneficiaries. The only time people can benefit from an intestate succession is if one, you're either a spouse or a child of the deceased. Those are the first people to be considered. Outside that circle, if if Kioko is your friend and you intended to pass on one of your prime lands in Molo to him, and you don't do it through the other means, now you can't do it. Once you go and you have no will, you've not passed on in the other ways you have seen, now it is about the spouses, it's about blood relationship or marriage. Anybody else who comes after that, brothers, sisters, parents, will only come in to prove they were dependent on you. The latter category, the first category of spouse and children, do not have to prove dependency. They inherit as a matter of course, and there is a lengthy, tedious process of dealing with intestate succession. Once the owner of the property passes on, the spouse, the children, or spouses in this matter, because even polygamous situations are taken care of, sit down and they have to identify amongst themselves an administrator. The administrator is the person now to take charge and distribute this property to the intended beneficiaries. So the law doesn't care now. The law has said you're either related to me by virtue of marriage or by virtue of blood. I'm linked to you by blood. So they sit down and they have to identify an administrator. Priority is given to the spouse, followed by the children. You can imagine in setups where we have different, we have several families. Even sitting down to agree on who's an administrator sometimes takes years. That time the property is still being used or even being wasted. Then after they identify the administrator, they have to identify the properties left behind by the deceased. Again, kibarua ngumu sana. Sometimes, and this is very common with the male gender, they have things, you have no idea where they are. Their properties in Kwale, the documents are put in some briefcase somewhere. You've never known whether it represents a property he owns. And you have to go through all that. You have to trouble yourself. Sometimes you might be thinking that the building you've been staying in is his. You realize it's not. So you have now to dig through his information, through maybe his friends, and legally ascertain that this is his property. That list is now put down. Next step, you have to sit down and say, these are his people. This is the wife or the wives. These are his children, and list them again. And this is where sometimes you see things coming up. I was also a child of his, because there is no certainty in the whole process. But you, as the people who are left behind, must identify those things. So after you do all that, you still cannot divide this property. The local administration is involved. Indeed, if you die in the state, or actually if a death occurs in a locality, the chief, the sub-chief should ideally report that and move in to ensure that no property is wasted. So the chief or the sub-chief will give you a letter showing that as far as we know, remember now you are gone, you refuse to follow the other two systems we have already discussed. Now you are in a situation where the law is dictating the steps. The sub-chief or the chief will give you a letter, again detailing out, this is the much I know about the deceased heir. These were his wives, these are his children. As Kenyans, we all know sometimes what plays out in these scenarios where the administrators come in to issue letters. Sometimes they will put people there which have been objected to, sometimes they leave others, and you have to live with that because the deceased decided to live. Now, after you have collected all this information, and assuming you are doing it through a lawyer or through yourself, the lawyer can only act when you give the information. Now you go to the next step, and that is now approaching the court. In approaching the court, you now list the administrator, the beneficiaries, the properties, and you must also get two other people called sureties who must come and assure the court and the law that in case you mess as an administrator, they will come in and stand for you. They give a guarantee to the court that they are willing to come and make sure that you do the right thing. So after they sign that surety, you now file the whole bundle of documents to court. The court will look through it and see whether it's compliant in terms of the law. And it is now put in the Kenya Gazette for a whole 30 days. The Kenya Gazette will advertise it for 30 days. This is to see whether there are any objections or whether you are lying. I mean, you have let it to be liwalo because you did not decide. Now everybody else is invited in the whole world to come and stake a claim if there is any. So after the 30 days are over and there are no objections, indeed, let me pinpoint that many times within those 30 days, that is now when the Act 2 of the drama starts. That is when now things crop up. There's a whole lot of process there. People come in as objectors, people come and say, he owed me this, and the whole issue is opened up to the whole world to come and comment. And it's a bit torturous to the beneficiaries who are dealing with it. Just to pinpoint that it's also dictated by the law that if they are minor beneficiaries or children of the deceased, the administrators must be 2 or up to 4. You cannot take the letters alone if there's a minor involved in that estate of the deceased, because it's presumed there's a trusteeship that comes as a result of having a minor. So if you have a minor in the family of the deceased, the administration must be 2 and up to a maximum of 4. So after that days are over, and luckily, I'm using this word luckily, advisedly, because I have seen drama. Luckily, nobody comes to object. Luckily, there are no issues. And luckily, somebody somewhere at the corner of the world has not seen the Kenyan Gazette. So there are no objections, there are no problems. You go back again to court. The court now issues what we call letters of administration in the state. Now naming in the administrator, and the administrator or administrators now will come in to look again at the property, collate it, look at the nature, if they need to follow up, if there are disputes. Now they can sue and follow up on your property. They can approach everybody who is holding anything belonging to the deceased and now collate it in one court, determine the value, and start the process called distribution. Again, you are not done. You have now collected the property, but the law does not give you the permission now even to distribute it, even at that point in time. Once you have identified the property and you've identified the beneficiaries and their shares, you must go back again to court, presumably within 6 months. Sometimes it takes years even for people to identify this, but the law requires that within 6 months, come back to court, give us a schedule of how you intend to distribute this property. And at that time, everybody else is called upon who is a beneficiary to come to court and say, I'm happy with this. And then the court gives a nod that go ahead and distribute it in the terms you proposed. What I'm doing here is a very summarized summary of actually what happens in real life. Sometimes you find that even the distribution, we have gone through all these processes, but someone says that I'm not happy with this distribution. So we can go to court, and if I go to court, I will protest and say, no, this property is not distributed in the right manner. That leads me to the question of, as an administrator who has been appointed under intestacy, how do you distribute this property? And the law gives something we call a life interest to the spouse. The person who has been left behind, the widow or the widower, as what we call a life interest in the estate. In other words, that spouse can use that property until the time either, and this has been a subject of a lot of debate, she marries, but not he. Either she remarries or she passes on. That is the time the property should ideally be left for the children. But the spouse has no power, contrary to what sometimes happens, to dispose of the property without the permission of the court, or even to distribute it without the permission of the court. Among the children, be they male or female, they have what we call an equal right to inherit from their deceased parent. An equal right is not, it's what we call equity as opposed to equality. What do I mean by this? Sometimes you find that in a family, there are people who are old enough, who have been around for 40 years, others are 10 years old. I mean, if you have $1 million and distribute this one equally to these people, you'll have disadvantage to this person who is young and who is still in school. So the law comes in and says it is about equity. If you get 10,000 and somebody else get 100,000 because he's still in school, the law will not come and say it has to be equal. The other thing I have to emphasize is if during the life of the deceased person, he had given you some property, say I'm the firstborn in my family, for example, and my father, along those times when he's happy or I've made him happy, he says, this land is yours, and I transfer it even to you when I'm alive. When we are distributing the property in an intestate succession, we will consider that during the life of the deceased, you benefited. So we'll take we factor what you got from the deceased when he was alive. But to clear the hair, all children have an equal right to inherit from their deceased parents. And that equal right is what I'm calling, it has to be equitable as opposed to equal. It may not be shilling for shilling, but the court must legislate that and say, what happens? And sometimes the court will ask you, are all these people of sound mind? Are they capacitated? Because the court can look at it and say, we have a dependent here who is incapacitated in one or the other. We must take care of this person in this manner. In other words, intestate succession has a lot of control by the court. The court is the driver, and the law. You cannot do things outside that law. That's why sometimes you see widowers or widows coming back to court to seek permission to sell a given land to take their children to school. They can't just do it, unlike if it has been a trust or it had been willed out. So those are principally the processes that you undergo if you die in the liwaliwalo situation I alluded to in my presentation. Mr. Bwire had discussed questions of where dependents don't feel like they have been taken care of. You can have a situation where this process of intestacy can go on until to the end. And then Mr. X, somewhere in Australia, comes up and says, wait a minute, I'm the son of so-and-so, and I'm not in this. So there are situations where some people can come even in these intestate processes, and they're allowed by the law to come and prove if they were actually dependents or they are the children of the deceased. So you can see the situation as an owner of property. You will put your people, your immediate people in if you do not plan early. But luckily, the law actually has developed in this area so successfully, and we have decisions determining all the rights. An example, a good example is there was a court case sometimes back, actually before the 2010 Constitution, where a man had married a lady called Irene in the church, and along the way he went back to his homeland in Ukambani and married another lady, and they got a child through what he thought was customary marriage. And during his life with the first wife, he had acquired property with her, and they were joint owners in that property. But now, when he died, there was no will. So the first wife went to court, of course, to inherit everything from Mzee, because according to her, she was the truly married wife, because she was statutorily married through church. This other one, by law, would not even be married. But again, the second one also knew that I am the wife of the deceased. So what happened is, when the case went to court, because the second wife now came with the son to object, and they say, we are also the family of the deceased. And it's one of the most celebrated cases, because what happened, the court came and said, fine, whatever was jointly owned, that is survivorship between the deceased and Irene, the first wife, is ours, because that has been taken care of by the survivorship aspect. But what was remaining, actually in the whole estate, was an account in one of the banks, HFC, and the court, and this was actually at the Court of Appeal level. The Court of Appeal said, we have a child here who is born out of the second marriage. She is a lawful dependent of the deceased, but we do not want to be seen to be disinheriting widows who have left behind. And they said, because this child is still young, the first wife was given, I think, 100 bob, and the rest of the estate was given to this other child. So that you can see the way the law will play around it. Yes, you are entitled, and we're not going to leave you with nothing. We will give you something, not so that we don't set a law that people can be disinherited, but the person who is more needy and who might need this estate more is this child, and that is what happened. And that was the end of it. So situations will arise, and many situations will arise that will require the court's intervention, especially if the estate is left in the liwaliwalo situation, the intestate succession. Wewe wamevumuzika, mjipange wale wamebaki. That is some of the things which come into to the fore once you are gone without a plan on estate. Customary law and estate succession. I want to pinpoint that challenges come where people come and tell us that according to our custom, so and so is not supposed to inherit. I want to make it very clear that customary law is limited in application, and it's only limited in some areas which have been gazetted, mostly the pastoral areas of this country. Everybody else who died after 1981, when the law of succession came into force, is bound by that law, and customary law does not apply. Similarly, I need to pinpoint that Muslims, since 1990, were exempted from the strictures of the law of succession, and that their succession is done through the qadis, through the Sharia law, except that a Muslim man can also do a will, and the rules will apply, but he can only will out a third of his property. The rest, the 2/3 must go to intestacy, or rather must be dealt with through the Sharia law. So those are some of the points I wanted to highlight in this presentation. And I hope you are also raising up your questions on the Q&A. But there's, just like in real life, succession and estate planning are intertwined with the whole rubric of family law. And the family law is wide. It deals with children, deals with divorces, it deals with many other things. But it's a very dynamic, it's one of the most dynamic areas of law, because as we sit here, I know there are bills pending in Parliament, trying to even in the service for many other people. There's been questions which have been answered recently, as late as 2021, about why is it that the law provides that if a widow remarries, they are taken out of the succession equation, yet when a widower remarries, is not taken out of that equation. So the ground is still being laid out to be even for everybody, and there are so many recent developments which keep on coming. We have things pending in the court to determine questions of what happens if the Marriage Act is very clear that you cannot contract another marriage if you have done statutory marriage. Why are other people coming in to inherit when they are coming in after the first statutory marriage? So those are some of the things which we call as conflicts of laws, but we have questions coming every other day. Family law is as dynamic as families are, and every other family I have met in succession has a unique question, but you must put yourself within that cubicle of either you are either transmitting in your lifetime, you are either transmitting when you are alive to pass on when you die, or you leave it in the intestate succession, which I have tried as much as possible to summarize in the short period we have. So in conclusion, it is advisable that as we sit here tonight and as we do this webinar, we are toiling to acquire. We want to live on our property, and we would not, I doubt whether anybody would want to see scrambles or have issues when he's gone. So it is a question of minimizing the risks, start planning early, fear nothing. The property many times is yours, even in a will setup. You do not have to fear. It's only, a will only comes into effect when you go. So you don't have to be worried that if I put in the will, it's not mine. No, it's yours until the day you breathe your last. So the power is new to dictate the way you want your property to go now and even thereafter, especially if you have means, if you have something you know you can hit and leave behind. Please look at it from the perspective of you do not want it to go back to the liwalo situation. Ladies and gentlemen, thank you so much for giving us your ears. We are now ready to take the questions and try as much as possible to answer them before time for dinner, for those who take late dinner. So back to you, Esther. You can take the Q&A.
Thank you very much, Mr. Kioko and Mr. Bwire, for the elaborate presentation. I will now give participants an opportunity to ask questions. So you can raise your hand if you have a question, and our technical team will unmute you to enable you to ask your question. And meanwhile, I see we've got some great questions coming in the Q&A segment. In case you're yet to establish where the Q&A segment is, at the extreme bottom left of your screen, there's a triangle, a square, and a circle icon. Click on it, and it will direct you to the Q&A segment. So I'm gonna ask a question. I see someone called KD. I don't know whether that's short form for King David. He's asking, do insurance policies fall under nominations? I think Mr. Bwire, you'll respond to that. I see one, Mr. Njuguna, asking, my mom passed on testate mid-2022, but we're still in the process of resolving her estate. Is this lengthy, delay normal? So that's a question from Robert Njuguna. I see a question from Jacinta Kahiga, and she's asking, what if I change my mind? How easy is it to change my will? Mr. Bwire will respond to that. Another question from Anonymous, and he's asking, can a child take a parent to court to pursue their inheritance if there's a risk of the property being misused? Should the surviving spouse remarry? I think Mr. Kioko will respond to that. I also see a question from Ivy Tesmwangi, and she's asking, what happens in an instance where the same property is bequeathed to more than one person under the same will, but the will fails to define how the property should be distributed among the beneficiaries? I don't know whether Mr. Kioko, you understood the question, but I can repeat it if you are yet to understand what the participant is asking. And lastly, we have a question from someone called AK, and he asks, which dependents does the law recognize? For instance, regular contributions to a charity or employees. Do these groups or individuals, or can these groups or individuals claim that they depended on the deceased? Or I also see another question from Harriet Sam, and she's asking, what happens if a trustee dies before the owner of the estate? I think Mr. Kioko will respond to that. I also see Mr. Daniel Mwangi has raised his hand. I don't know whether our technical team is able to unmute him so that we can hear his voice and his question. Daniel Mwangi, are you able to ask a question? Are you unmuted? All right, as we give the technical team an opportunity to. Okay, go ahead. Go ahead.
Thank you, NMN Law Group, for this insightful discussion on succession law. Congratulations on holding this, and we appreciate, as well as the general public and fellow advocates, we appreciate the invitation and the sharing of information. What I'd like to know is on the issue of creation of trust. Can you kindly expound on the tax benefits, as well as the various kinds of trusts available? From my own research and knowledge, probably we have the irrevocable trusts and the revocable trusts. Particularly, I want to understand the import of the irrevocable trust as a manner of distribution of assets, and how does one arrive at the selection of the trustees, and what are the benefits of creating a trust which is irrevocable towards the management of an estate as a beneficiary of the estate, as well as onward transmission of the residue of the estate to other beneficiaries named in the trust. Thank you.
Thank you very much, Daniel, for your question. So I want to afford the presenters an opportunity to respond to the questions, and then we will get to the second session to allow other participants to ask questions. That is, if time will allow us. So Mr. Bwire and Mr. Kioko. I think Mr. Kioko, you can go first.
Thank you, Esther. And let me start with the question by Daniel Mwangi. The question of creation of a trust, like I've said, it's getting a lot of traction in our country of late. And there are two ways I know the trusts come about. And one is what we call a testamentary trust. And the second one is a life trust. As a testamentary trust is where you do a will that principally just says that all my property or this property go to be managed by my trustees for the benefit of my beneficiaries. That is a testamentary trust. It is contained in a will that only passes on to the trust. The life one is a life trust is where you yourself create it now when you are alive, determine the questions of who are the trustees, what are you going to put in the trust, and who are your beneficiaries, and how they are going to benefit. So that one is a life trust. You are creating it while you are alive, and because once you create a trust legally, it gains a legal personality. And the law requires they must own property. And then you have offloaded everything to the trustees to manage it according to the wishes of you, the state law, for the benefit of the beneficiaries. The questions of revocable and irrevocable trusts, I have painstakingly researched on that, and my very uncollaborated take is that everything that is managed within the law of trustees for perpetual succession is capable of being revoked, whether you say it is revocable or not, because I'm looking at a situation where, as a beneficiary, I've seen the trustees are falling foul of the settlor's wishes. Or as a beneficiary, I'm not benefiting in accordance to what was dictated in the trust. It cannot be that you have no remedy, because in a trusteeship, we have a tripartite relationship. The giver of the property is at law, the trustees, and sometimes some beneficiaries can also be trustees in the same trust where they are beneficiaries. You, the beneficiary, is a stakeholder. The trustees are stakeholder because they are not only given powers by the trust deeds established in the trust, but also by the law. And they must act within the fiduciary duties bestowed upon them by the law. So as a beneficiary, you are not limitless. And the fact that somebody's drafted and says it's irrevocable, to me, to my mind, if you fall foul of the law or the trust deed, that deed will be subject to operation of the law. So fine, I have seen that kind of indication. It's revocable, but for me, any instrument or any regime of succession that operates under the dictates of the law is subject to a revocation if it's not doing its duty. I know there's been a lot of changes between 2020 to present as far as the law of trust is concerned, especially the law of perpetuity and accumulations, and many amendments came that meant, for example, family trusts. There also are categories of family trusts, charitable trusts, trusts for sale. There are different kinds of trusts, of course, the formations. And I know family trusts for a long time used to enjoy a lot of leeway in tax regime. But it has been a serious reduction in those benefits as the government opens up those trusts. So the tax benefits now are very minimal. The only thing I would say is setting up a trust is fairly well priced. It's not as expensive as other regimes. So the tax benefits people to enjoy in terms of health, education, and this kind of thing have now been clawed back. And the only thing I would say is for a family trust, the perpetuity period has been removed. But in terms of tax benefits, they are very minimal. And actually, if what we are seeing going around now, if the bills comes back and it's a form it was, they will be gone kabisa. But there are still benefits to a trust. And one of the benefits is to avoid the situation that comes in when it is free for all, when you go to intestates. And the beauty is, when the property of the deceased is transferred to the trust being a legal person that owns the property, is the one now responsible to give to the beneficiaries. You do not have situations where an outsider comes and says, I'm independent. If you are a child and you are left out of that, your remedy is not now in the succession, it's not in the trust, because you are not named in the beneficiaries in that trust. So the trust owns the property now. It is no longer the deceased property at all. And because it's been taken out of that regime of succession, you have actually passed on the property while you are alive, totally. Other benefits that come with trust is this. Of late, the embassies as succession lawyers we are putting on trust is, it is sometimes good to bequeath your dependents or your children, for this matter, with the proceeds from the estates as opposed to the estate itself in raw form. Why? Dreams change. The world changes. I'm a transporter in my lifetime. I have perfected that art. I know the ins and the outs. Najua kora zote, najua kila kitu. But my children may not necessarily share in that dream. And sometimes businesses will follow, or estates will be mismanaged, not because the dependents wished to mismanage them, but because they don't share in that. But if I throw in this transport business of mine to trustees, who I have chosen and who can be chosen through the law, and they have the expertise to manage this, then my independents will benefit from the proceeds. They will be taken care of education-wise, health-wise, housing-wise, without necessarily having them get involved in the actual sharing of the meat, in the actual get this tractor, get this, because dreams change. People have different perspectives. So one of the advantages is you are leaving it in competent hands, and you are sure generations and generations can benefit from your sweat. So in a nutshell, Daniel Mwangi, and your voice sounded like a Kanzo, I know. In a nutshell, those are some of the benefits. But for the benefit of the other questions, I will ask that we can also share our emails and engage further on that, because it's a very wide area of law. I hope I have answered that question on the trust. The next question, Esther, you will read a few other questions. I can go to Harriet Sang. And the first one was, does the owner of the estate have the power to choose who will be the trustee in case he wants to create a trust? And I will say absolutely yes. Remember, until the property goes to the trust, it is your property. You can choose the trustees you want. Indeed, it's encouraged that you choose people with expertise and the people of integrity, people who would step in, people who would ensure that your property is not wasted. People will ensure that it's passing on to the intended beneficiaries. So yes, a trustee, trustees can be chosen by the settlor or the person who owns the property while alive. Or even if it's a testamentary trust, he can indicate the people he wants to be the trustees. What happens if a trustee dies before the owner of the estate? Trustees in the trust deed, usually there is a provision for our trustee can resign, can be removed, can be replaced. If the deed is silent, and hardly do they get silent on that, the law, Cap 167 of the laws of Kenya, will come in and determine who is eligible to be a trustee in that situation if the testator has died. A trustee, as it is, as the word just literally means, is a person who put in a duty, a respectable duty to do the right thing. So the set law has a chance to do so, to choose the trustees, or the law can come in if the deed does not provide for procedure. I think KD, Mr. Bwire, you want to answer the one on the insurance policies fall under nominations?
Yes. On the question by KD, I can see he's asking, do insurance policies fall under nominations? My answer is yes, and particularly I want to believe you're asking matters concerning life insurance policies. In such a case, under such policies, you'll always be required to nominate or to indicate the person who will stand to benefit in case the risk you are insuring will attach. So yes, insurance policies, and more particularly life insurance policy, fall under nominations. On to the next question. I have seen a question by one Jacinta Kahiga. She's asking, what if I change my mind? And how easy, what if I change my mind? How easy is it to change my will? For Jacinta, that question can be answered in various ways. There are various ways in how a will may be changed or amended. In the case where you may need to update the will, for example, when you're preparing the will, you have indicated certain properties, and in the course of your lifetime, perhaps you've acquired new properties and you wanted them to be factored in. In that case, you could prepare a document called a codicil. Without necessarily destroying the previous will, you could prepare a codicil that still follows the format and the legal requirements of the will, save that the codicil will only be factoring in the new properties. And also, in a case where I want to assume that Jacinta, in her question, intends to mean that, you see, me being the testator and my dispositions in my will have changed my mind, and I don't want things to be done the way I had previously indicated. One of the safest ways is you do a new will. You prepare a new will with the same procedure that you had used previously. And what happens now to the old will? It is advisable that when you prepare a new will, you ensure that the old will is completely destroyed. The old will should not be folded. There are case laws that have decided that that will needs to be completely destroyed, so as for the court to interpret in case someone picks it, the old will, the court should interpret that the intention of the testator then was to destroy, and actually the will has been completely destroyed. For example, if you take an old will and you punch it, and still the writings can be read, that can easily be construed or could be easily interpreted to mean that there was no clear intention to destroy the will. So it is advisable to destroy the old will completely, so that one may not come across it to read it, to maybe object to the new will you'll have prepared. I know there are other styles in which a will are prepared where there is what we call a personal property memorandum. There are wills that are prepared where in that will, there is a statement to the effect that my properties will be distributed as per the attached personal property memorandum. So that you have a will that is attached. There's an attachment by what we call that personal property memorandum. If that is the case, then you don't need to do a new will. You don't need to do a codicil. So that means you won't be required, or you may not need to destroy the old will. You'll only need to replace that personal property memorandum to reflect what your new intentions are. I want to believe I've adequately addressed the question by Jacinta. There is also a question by Anonymous. You're asking whether a child can take a parent to court to pursue their inheritance if there is a risk of the property being misused should the surviving spouse remarry. This question, I want to believe that the word child does not mean a minor for purposes of succession, because in succession, a minor may not be allowed to take out letters of administration on their own. Of course, where they are minors, there should be administrators, at least 2 administrators who can take out the letters on behalf of the minor involved. So if the child is, for purposes of the question or for purposes of succession, if the child, we presume that the child means a mature person, an adult, still being the child of the deceased, but an adult. If there is a feeling that the property may be misused and the spouse, being the parent to that child, has not taken out the letters or has not applied for succession, the child may decide to follow a procedure where he may take out citation. Citation is where in the list of priorities of people to take out the letters, the spouse comes first before the child. Actually, it's the spouse and the child, and in that order. So where the child feels that the parent, now the spouse, is likely to misuse the property, and without necessarily going through the succession process, they may cite, they may take out citation, they may approach the court and cite the parent. Citation is where you feel that in as much as you are eligible to apply for the succession, there is a person who is given priority before you, but they are not taking it out. So in this case, the child may approach the court and cite the parent to take out the letters. If the parent will not take out the letters, then the court will now allow the child to take out the letters in place of the parent. I want to believe that has been answered. Okay. Let me go through other questions. And there's also the question of, there's a question by AK. AK is asking, and particularly on the issue of dependency. AK is asking which dependence does the law recognize? For example, regular contributions to a charity, employees, these groups stroke individuals could claim they dependent on the deceased. For purposes of succession, Okay, dependents are defined. There's a definition given to dependents. That is the wife, or wives, or former wives, or children of the deceased, who necessarily don't have to prove dependency on the deceased. So basically, it's the wife or wives or former wife or wives and the children of the deceased. Any dependent must prove that they actually they were dependent on the deceased during the lifetime of the deceased. So employees and charity institutions, I don't believe they fall under the definition of the dependents. And maybe perhaps I could also invite my colleague, Mr. Kioko, maybe to give further clarification or contributions, and also answer some of the questions, whether the ones I've answered or ones that have not answered.
Thank you, Bwire. Let me just also add on what actually you have very well elaborated on the anonymous question of a child taking the parents for inheritance. Yes, I mean, as a beneficiary, you have a right to protect the estate of the deceased. And I'm looking at a situation where surviving spouse remarries. If, although like I indicated earlier, that the law has always been pro the male gender, and it only talks of the remarriage of the widow, and not the widower. Although the court recently said that was discrimination, but the legislature is led to incorporate that. But yes, if there's a risk of property being misused and the inheritance being messed up, assuming there is already a succession which has been done, or there is a will, you have a right to pinpoint that. Actually, courts are ready to protect estates and to see whether what you are alleging is true. Yes, that can be done, because misuse is always a possibility. Perhaps also to clarify, and this is very interesting, wills, Jacinda Kaiga, wills can also get revoked. They get revoked by operation of the law. Sometimes, like when somebody remarries, if you have a will and you've remarried, you have that will is automatically revoked by marriage. So wills, it's your will, it's your intention. So you can change it anytime. And there are some steps you can take in life that will revoke your will, like a remarriage. So yes, those are some of the situations we face. Further down to Ivitesi Mwangi. What happens in instances where some property is bequeathed to more than one person on the same will? However, the will fails to define how the property should be distributed among the beneficiaries. A very interesting question, Ivy, there. One of the things I need to pinpoint is that a will is an expression of intention. Sometimes, actually, a will does not guarantee that the property will pass to the intended benefit heirs. Why? Because the law presumes, whether in the state or testate, whatever is available for distribution is the net, is the residue of the estate. Surprisingly, even if there is a will and the executors, the first people to be taken care of is liabilities. It's very possible for somebody to will out property and realize that the net assets are less than the liabilities. In that case, even if you are an heir to that will, the liability will be taken care of first before you come to the equation. So you can have a will that actually has passed on nothing. But more specifically, if there is something, a property has been passed on in the same will, and the people, I want to imagine this as a situation where more than one person under the same will is the same property passing on to A and B. My property D is going to A and B, and the shares are not defined. There's an elaborate process to deal with this. There's something called, if the property that is being willed out, the shares are not defined, it is presumed that these people are going to share it in equal measure. Sometimes the property has already been given to one person, the other one doesn't have anything left. There is a principle called the principle of redemption. In other words, the property, the way it has been passed on, does not exist in that form. So if it is passed on to two people and it's still available, those people should be able to share equally, because the will is a will is an ambulatory instrument. It can mutate and depending on the intention of the testator. But it does not necessarily mean that because you are named in there, you only get the residue of the estate, even in a will situation. Okay, I think has been answered. A question of the independence. Charitable organizations and the employees, those are different relationships. They cannot really form part of dependency unless, of course, somebody can be able to show by evidence that he was dependent on the deceased. There was a question by Robert Juguna. Sorry, we've been jumping it around. My mom passed on testate means 2022, but we are still in the process of resolving our estate. Is this length and delay normal? Mali ya mwenyewe ni ya mwenyewe na ina maneno yake, but it is not abnormal to have this situation. I know one of the estates of one of the prominent personalities in this country. I still see it in our course list today. It went to court in 1981. And I know, as a matter of fact, they are still on it. They have not finalized resolving the issues. So it's normal, but it's a question of what are the issues that are preventing this estate being administered and to have those things rested. Are there questions of people unsatisfied? Because if she was tested, it means she had a will and she had given out what must to be done. At times, people do wills and do not even point out who are going to be the executors. So you still have to go back to court to get a probate and appoint somebody to be the executor. Sometimes the executors renounce the executorship. So I do not know what is the particular problem, but what I know is of late, and this is from what I observed since the year 2021, post-COVID, the family division courts have been very fast in resolving some of these things. So Robert, we can engage. We'll give you our contacts to see what could be the impediment to administering this estate, because mom had done a will, she was tested, and that should have resolved a lot of things. Sometimes people procrastinate on these issues for no apparent reason, sometimes for no lack of knowledge, sometimes because people are not happy, but their happiness should be addressed as fast as possible so that there's a determination. Esther, I don't think we have left anything unanswered. We've attempted as much as possible to answer the questions and if there are.
Thank you, Mr. Kioko and Mr. Bwire. I did say Mr. Eli had raised his hand. Mr. Eli, are you in a position to ask a question? I think he must have left the chat. Any person who wants to ask a question?
Yes, if I may, Esther. Should I continue?
Yeah, proceed.
Yes, my name is Daniel, and I appreciate Mr. Kioko and Mr. Bwire for the well-answered questions. And I thank you for taking the time to research on the issue of estate planning. And probably what I would want to ask as a follow-up question to the one I had asked, which Mr. Kioko very ably answered, as a way forward, given the global nature of business as it is right now, and also taking into account of the taxation measures which our government has taken in line with its mandate, and also following on that, the duty of every person who is earning an income and who is
adhering to the adage that every person leaves an inheritance to their children and children of their children, would it make sense to probably consider what the laws in Kenya probably will guarantee an investor of a global perspective who has, for example, taken advantage of the American approach to management of trusts and their generational wealth management perspectives, especially where it concerns leaving wealth to people who are now and later. I would want to propose from this meeting that probably we can have a further engagement on how investors and generally Kenyans in general can take advantage of, I'll use the word loopholes, quote unquote, to having and retaining wealth created now and in further generations so that it can benefit us in the kind of perspectives we have. What I have in mind is that if you look at the European perspective and the American perspective, there are tax breaks that come about through having donations given to trusts which are in the perspective of generational wealth, as well as the ones that are geared towards offering charitable purposes. Is there a way we can incorporate the same so as to offer a full component for the people who intend to benefit from creation of trusts as a way of guaranteeing protection of investments from inheritance perspective? Thank you. I know you don't need to answer my question now, but I know we can have a further discussion in other discussions in subsequent webinars. Thank you, Mr. Kioko, for taking the time. I think I'll admit I'm fellow counsel. I was intrigued when I saw the invitation to have this discussion, and I appreciate M&M Law for taking the lead in this discussion. Because after all, even you and I, we are in practice and other businesses so as to make money and wealth. If we do not find a way to leave it to Esther and the rest of us who benefit from us, then we have no way of managing our outcomes. Thank you. Let me leave it at that.
Yeah, thank you, Daniel, for your question. Mr. Kioko, before you respond, I'll beseech you to make your response short and sweet. Insult
Okay.
is always motto.
All right.
We need to go and see what Trump is saying about the victory.
Thank you, Council Daniel, and I really appreciate your sentiments, and I share in your observation that this country must embrace the best practices. When I was researching for this paper, I looked at jurisdictions in India, I looked at UK, I looked at the Rockefeller Foundation, like in the US, and how they operate. And it's very interesting how those jurisdictions have come up with mature systems. I know we've destroyed a bit of trust law since 2020 or thereabout, in terms of weakening the tax, or rather increasing putting the government's hand in the pocket of the trust. But I don't think anything is lost. We still are on track. Indeed, as you are aware, recently we used to take years to register trust. Now it's been made a bit easier. And I think going forward, our legislators will be able to see the beauty of making our trust work the way they have always worked in other countries. It's very interesting how you find generations over generations have benefited from a trust that has been very professionally managed, and people have respected that trust. As it is, of course, our laws operates within the society we are in, and we know we have examples of trust that have also been set up and become a menace. So yes, I think we need to look for each other and engage, and I encourage everybody, of course, to engage as we look to better this situation. Esther, I have tried to make it as short as possible. I back to you again, but let me just thank all those people who have taken their time to stay with us up to this moment. Thank you so much. We don't take your time for granted, and we know you have better things to do, but you've listened to us, and you have. We appreciate your feedback, even through our emails. It's been displayed on the screen. Our calls, we can engage further on this because we are trying to summarize very many laws, very many situations in a short span of 1 hour. Thank you so much. Back to you, Esther.
Yeah, thank you very much, Mr. Kioko and Mr. Bwire, for the elaborate presentation. To the presenters, if you have any further question, our technical team has sent a link to a Google form. You can just fill in the question in the Google form, and we'll be able to respond to your question via email. Now, ladies and gentlemen, that marks the close of our webinar. Thank you so much for joining us today. We hope you found this session on estate planning both informative and valuable. Again, a huge thank you to our presenters, Mr. Kioko and Mr. Bwire, for sharing your expertise with us. Now, before we wrap up, we'd love to stay connected with you. So make sure you follow us on all our social media platforms. That's Facebook, LinkedIn, Instagram, and YouTube. We go by the name M&M Law Group on all our social media platforms. Now, if you have any further questions or personalized advice, do not hesitate to contact us. We are here to help you, and our contact details and physical address are indicated on the slide on your screen. So thank you once again for attending this webinar, and we look forward to connecting with you soon. So have a wonderful evening. Until next time, bye-bye. So you're free to go watch your prime time news or engage in any other activity that you intended to do so. Bye-bye.